All rise. Court of Appeal for the 5th District, State of Florida is now in session. Honorable Richard B. Orfinger, Judge, presiding. Mrs. Orfinger, for the COTA, United States of America, State of Florida, and this honorable court. Please be seated.
Good morning and welcome to the 5th District Court of Appeal. We're here this morning for oral argument, and I'm joined on the panel this morning by Judge Jay Cohen on my right, and visiting us from Ocala we have Judge Brian Lambert, and we welcome him back. We have 3 cases this morning, 2 criminal, 1 civil. Parties will have 15 minutes per side in the criminal, 20 minutes per side in the civil. If you'd like to reserve some time, please let me know, and I will, assuming that you're the appellant, I'll let you know and you can do so. If you have a cell phone, we would appreciate it if you would silence it so parties aren't interrupted. And with that, we'll start with our first case, State versus Kyle COTA.
Good morning. May it please the court, my name is Ann Phillips. I'm here on behalf of the appellant, the state of Florida. I'd like to reserve 5 minutes for rebuttal, please. The state is here today appealing the downward departure sentence that the trial court imposed upon Mr. COTA. It's the state's position that there is not competent substantial evidence to support the single reason given by the trial court to depart.
But the reason was cooperation with law enforcement, correct?
Yes, Your Honor.
It seems to me that most of the cases that you cited in your brief address situations where either an arrest had been made or there certainly had, at the very least, as probable cause for an arrest existed at the time that law enforcement became involved with the suspect in the case. Would you agree with that analysis?
Yes.
Okay. Now, in this case, there was no probable cause to arrest. In fact, the officer who went and had contact with the defendant termed it a fishing expedition, I believe was his phrase. Is that correct?
That is his phrase, but yes, but the state disagrees with his conclusion.
The packet that was sent didn't include, for instance, the allegation that there had been a nude photograph sent up to Canada, correct?
It included, we don't know exactly what they got, but there was the discussion. The packet, as the evidence shows, had the cartoon, the sexually explicit cartoons.
But there was nothing illegal about that, correct?
I believe that there was.
What law was broken?
Because I believe that
What law was broken?
I would say that Section 847.0138, the transmission of material harmful to minors by electronic device or equipment, would have been violated by that. Because material harmful to minors is a very broad thing, something that is sexually explicit, that is transmitted, that is not appropriate for minors. And I believe that the nature of these cartoons, if they were so offensive as to not be admissible or to not be admitted so that they would not be part of the court record, I certainly think that that would indicate their harmfulness to a minor. So I believe that
the fact that they're not part of the record leads us to conclude that they must be really bad?
No, I think it lends support to it. I think the fact that the police officer testified what they were, that they're sexually explicit cartoons that are basically animals are given human anatomy and in sexual in a sexually explicit manner, acting in a sexually explicit manner. So I believe that his description of what a furry cartoon is leads us to believe that it is a material that is inappropriate or harmful to a minor in violation of Florida statute. I believe that it's the state's position that the police officer's conclusion was incorrect, that he did have sufficient information at that moment to go get a search warrant to seize Mr. COTA's computers based on what he learned from the Canadian police. Additionally, this is just the beginning. The fact that he decided to go on a fishing expedition and simply because he did not go and get additional information because he went there shouldn't make this cooperation sufficient to support a downward departure sentence.
Why not? I mean, it's in the legislature. You puts this in as a statutory basis for a downward departure. And here, you've got an individual who opens his home. The testimony that we have in the record is that it was this fishing expedition, that he'd broken no laws in Canada, that he goes to the home, and this individual who was I guess a police academy student at the time cooperates fully, allows him in the house, lets him see everything that's on his computer. That's a basis for a downward departure based upon the legislative parameters.
It has, the case law says that the cooperation has to resolve this offense or an additional offense. He didn't help resolve it. At the time...
There wasn't even an offense at the time that the law enforcement officer went to the house.
I disagree. I think the transmission of that material was harmful.
But he wasn't charged with that. The offense that he helped resolve, using this line of reasoning, was the possession of child pornography. It wasn't the transmission. He was never charged with transmitting inappropriate material to the child in Canada. He was charged with having sexually explicit child pornography on his computer. Is that correct?
That is correct.
And the government had absolutely no reason to believe that that crime even existed at that point. They were there because he had allegedly sent a nude picture of himself to a 15-year-old in Canada.
Correct, which would be a crime as well.
Well, how would they have solved the crime without his cooperation, the crime that he was...
They had sufficient information to go get the search warrant. The fact that
It wasn't a crime
they didn't...
in Canada. That was not a crime.
It's a crime in Florida to send material harmful to minors across the internet. And that is what he had done. He had sent a nude picture of himself. He'd sent these furry cartoons to a minor. That is a violation of the law in the state of Florida. The police officer's conclusion that he didn't have enough is simply incorrect. And I would imagine, because it didn't happen that way, we can't say anything else, but I would imagine he goes back and tells his boss, I'm letting it go. He didn't cooperate. I imagine that would have been met with a little bit of resistance and said, get out there and do some more work.
Where in the record was that?
It doesn't have that, and that's what, which is what I said. It's not in the record because it didn't have to go that far, but the fact remains that he had violated the laws in the state of Florida. That at the time we knew who he was, we knew what he had done.
The record that we've got, the police officer says effectively if the guy says no, don't come, you can't come in, he was done. It was over.
Mr. COTA also did not cooperate in pointing out the different child pornography. He pointed out the Canadian girls' photographs or folder, but he didn't tell the police officers, oh, by the way, I also happen to have child pornography videos that have children ages 2 to 16. So he didn't cooperate in solving that offense. So I think the way the case law defines cooperation and the way that they talk about simply getting a search warrant not being sufficient to allow a search not being sufficient, I think we fall within that parameter here, and I think that the trial court's sole reason for departing is not supported by competent substantial evidence in this case. I'd like to reserve the remainder of my time. Thank you.
Good morning. May it please the court. My name is Paula Kaufman. I represent the appellee, Kyle COTA, in this appeal.
Ms. Kaufman, the state argues that the law enforcement officer's conclusion that he didn't have enough information for a warrant isn't particularly relevant to our analysis. I tend to agree with that thought. I mean, we don't accept necessarily, if a police officer says, well, I had probable cause, so I did this, I mean, we examine that independently. And so it seems to me that we are free to look at the other side of the coin and say, well, if what we look at are the facts, not the officer's legal conclusion of whether he had probable cause or sufficient basis to go seek a warrant. Do you agree with that, or do you think we're somehow limited by the officer's conclusion that if the defendant hadn't cooperated, he would have just had to close the door and go home?
I don't believe this court is limited by the officer's subjective conclusion if there was competent substantial evidence in the record to show that that conclusion was erroneous. As long as there is substantial competent evidence to support the reason given for downward departure in this case, this court has an obligation under its own case law to affirm. It's Mr. COTA's position that the reason for the state's opposition to the downward departure in this case is itself not supported by substantial, competent evidence. The authorities were on a fishing expedition in this case. This was a consensual knock and talk. This was a consensual encounter between Mr. COTA and law enforcement in his own home. Judge Palladna characterized the case in conjunction with the testimony of the state's primary witness as being merely a fishing expedition to determine whether a crime had been committed in this case. I would point out that not even the state below believed that this 24-year-old deserved almost 18 years in the Department of Corrections. The state basically wanted to control the extent of the downward departure with an uncoerced plea in this case, and they made an offer of 10 years.
Let me ask, so if there is probable cause, following what Judge Orfinger was saying, if there was probable cause for a crime different than what was the visual on the computer, and in the course of the investigation, whether maybe he labeled it a fishing expedition or whether he should have used that term or not, but in the course of his investigation, him believing he has probable cause, he has this consensual discussion with your client, and then your client says, okay, here, let me show you all the bad stuff I have here. I've got cocaine in this room over here. I got things on the computer. You're saying there's still that a downward departure sentence would still be permissible under the statute because he's cooperated in solving these other crimes, not the crime that the state was coming to see him on that day?
I think then we would be in the realm of the defendant's cooperation in the resolving a different crime than the one for which the authorities had probable cause to arrest or search. I would point out that this officer had no sworn statement from anybody at the time he knocked on the COTA's front door. He had no illegal photograph of anybody. He didn't even really have any reason to believe that the computer was in that house. It could have been in the shop being repaired. I agree wholeheartedly with Judge Cohen's comments. There was no probable cause for arrest in this case. And under those circumstances, since it's not in the record, I don't believe this court has any choice but to affirm the downward departure. I do want to comment, as I did in my brief, there is a paucity of decisional authority in this area. I was quite surprised. I don't know whether that's because this reason is rarely utilized to support a downward departure or whether that reason is rarely challenged by the state. I suspect it's probably a little bit of both.
Maybe trial judges don't impose a lot of downward departure sentences.
That is true. Unless the court has any additional questions, I'm going to rely on my brief.
Thank you, ma'am.
Thank you.
Just briefly, Your Honors, I would like to, in addressing Judge Cohen's question about our statement that there was already arrests in a lot of these cases. In State v. Ertl out of the 2nd DCA, that's 886, 423 cited in my brief, the 2nd District held that the defendant's actions in allowing the police to come in and search his home without a warrant and in giving statements did not justify downward departure. There's nothing to show in that particular instance that he already had been arrested.
Well, my comment to you was they either had arrested or had probable cause to arrest.
It's not certain right there, so I can't say for sure in that based on that fact. So I think it would.
Right. Did this law enforcement officer have a sworn statement?
I do not believe that he did. I am uncertain for sure, but he had the statements of the police. And again, he.
Well, Ms. Kaufman has represented that there was no sworn statement in this packet that was sent from Canada. Do you dispute that as a fact?
I cannot cite you a record site that says that. No, Your Honor, okay. I can't. But based on the case law, again, and the defendant did not cooperate to resolve this offense in that there was already probable cause to seize his computer at that time. The defendant knew they knew of a victim in Canada. They knew the defendant's name. He cooperated after his offenses had been disclosed to the police.
Let's talk about what the police knew. what they reasonably knew at the time they went to knock on his door. They knew apparently that he had had computer communication with a 15-year-old girl in Canada.
Correct.
They knew that he lived in Osceola County.
Yes.
There's no evidence to suggest that they traced the IP address back to the computer that was in his home.
Correct.
So it could have been a computer there, it could have been a computer anyplace else, right?
Correct.
Could have been from his work computer. And you have a work computer, you probably have a home computer. You probably have a laptop. I mean, there's a lot of possibilities there. What else did the state know that would have tied that house, that computer, to the communication? I mean, it's not enough to think that he was involved in a crime. I'm willing to accept for the sake of discussion that he did something wrong by sending these pictures to Canada. But to get a search warrant, you've got to show that the evidence that you're seeking is somehow connected to that crime. I mean, typically the way you do it with a computer is you would have the internet service provider tie the IP address from and the mail back to that computer. None of that was done in this case.
Correct. But the same thing as you said, it's typical for people to have the home computer. So they identified him based upon his uniform, based upon the picture that he sent with his clothing on, and they looked at his address based upon his driver's license. They went to that address, and he did allow them, but they could have gotten a search warrant for Mr. COTA's computers, and that could have been any of his computers.
Tell me what evidence that they had. If you were drafting the affidavit for the search warrant, what evidence would you have that would demonstrate, A, that a crime occurred, and B, more importantly, that the computer in that house was the one that was used in the crime?
I would draft the search warrant for any computer that Mr. COTA used. At that moment, he didn't have a job that had the computer. I believe he was in the police academy. So I would go for the home because I had the sexually explicit cartoons, and I had his information that he sent of himself, and I would go with that. I would say that I could go to his house and seize his computer and then do my search from at that particular moment and seize his computer and then find the additional stuff that went beyond
your view
Canada.
Essentially is as a rule of law, if a sexually explicit email is transmitted from a computer that, of course I wouldn't do this, so Judge Cohen has access to, that you would have probable cause to search any computer that Judge Cohen routinely has access to. That's the rule that you think applies.
I think you could do that. If you know that it came from a person, then yes, to find that, because of the societal harm that is involved with sending sexually explicit, harmful material to minors, I believe that I could access his computer.
So let me understand this. There's a difference because this involves child pornography as opposed to, say, some sort of financial fraud. Probable cause means something more because we find child pornography repulsive.
I don't know that probable cause has the definition of probable cause.
Well, you said
changed.
that because that child pornography is such a societal harm. I'm not promoting it. Believe me, I agree with you that it's not a good thing. But it seems to me that probable cause is probable cause, and whether you were looking for child pornography or financial white-collar crime on this computer, you either got probable cause to search it or you don't.
And it's the state's position that the police officer was incorrect in his conclusion that he did not have.
I agree that frankly doesn't tell me much. The fact that he thought he did or did not have probable cause doesn't impress me. But neither am I much impressed with the idea that you could get a search warrant simply by saying, well, he had access to one of these 10 computers, and so we're going to search them all.
I understand.
Have a good day. Thank you so much.